Thank you.
Let's discuss Ms. Danziger's findings and conclusions in the reports that she did submit to you, Doctor. First of all, in the December 4, 2013 report, did she make several opinions wherein she concluded that the defendant, Brandon Bradley, was under the influence of certain drugs as of the time that he was read his Miranda rights and purportedly waived those and gave a voluntary statement?
Yes.
She concluded in the report that the defendant was under the influence of first cannabis, secondly alprazolam or Xanax, 3 codeine, and 4 promethazine. Is that correct?
Yes.
Based on your review of her findings and the Wusthof lab reports, did you find any evidence to support her findings with respect to those 4?
There's only evidence to support the ingestion or use of marijuana and alprazolam. The toxicological findings were negative for the presence of codeine and promethazine. So really there was no basis for that opinion involving those 4 drugs in total.
Let's discuss the 2 that the lab reports did support. The one regarding the cannabis. There was a positive lab result for the THC in the system in the blood. Is that correct?
Yes.
And confirmed in the urine. So we know that for some period of time, Mr. Bradley had been using pot.
Yes.
Now, what information did Ms. Danziger report about the defendant's long-term use of this substance?
She had reported that the defendant had been using the cannabis since age 12, and his use was chronic and continuous, as well as the use of the cannabis was repeated every day.
And does an individual who, assuming that those facts are correct, does an individual who has this long-term chronic use of marijuana build up a tolerance to it?
Yes. THC is not unlike any other drug, that the repeated use and exposure to it would result in pharmacologic tolerance. So that means the actual psychotropic effects on the brain would diminish over time while the drug is used repeatedly.
And given the levels that were disclosed by the Wusthof lab, is there any way to sort of back extrapolate from the time when the blood sample was taken on the afternoon hours of March 7th of 2012 back to the evening hours of approximately 7:30 p.m. of March 6th at the time that Miranda was administered to Mr. Bradley?
No, it's impossible to extrapolate or estimate back to the time of the waiving of Miranda rights based on a single blood test for so many different reasons. One main reason is the half-life of the drug, and that's a measure of how fast it's metabolized over time. So half-life is the time it takes to metabolize a drug from one concentration to half of its concentration. We don't know the defendant's metabolic rate for either one of these drugs. There was some attempt to extrapolate the alprazolam. The half-life for alprazolam is somewhere between 6 hours and 26 hours with an average of about 11. So you can't extrapolate. You can extrapolate drugs with simple kinetics like alcohol, but you can't extrapolate drugs that have complicated kinetics like alprazolam, or even more difficult, the marijuana, because of the chronic nature of the defendant's use and the long-term nature of the defendant's use of that drug.
Now, given the fact that we know that there was marijuana in Mr. Bradley's system as of March 7th at 3:30 in the afternoon when the blood sample was taken, is there any way to determine at this point whether he was or how much he was under the influence of any marijuana at the time that the Miranda warnings were given?
No, it's not possible. It's too distant. To do it, one would need to have a blood sample that's collected at the time, which is
time the Miranda warnings were given.
Yeah, but in addition, there needs to be sophisticated measures of one's impairment, like what the police officers conduct on the roadside or in a station, which would be a measure of both physical impairment, physiological impairment, and mental impairment. So just taking a blood sample, getting it tested, and then going backwards in time, there's really no easy way or definitive way or accurate way to project or opine that he's impaired based on the blood concentration. It can't be done.
And with respect to the Xanax or the alprazolam, I think you indicated also that you could not do the back extrapolation with that?
You cannot, in large part because we don't know what his half-life was at that time. There's many different reasons. The only way you can do an extrapolation, so you know, is if you do repeated blood measures of the drug, and then you can actually calculate the time that it goes from one concentration to half of the concentration. But it's also important to know when the blood concentration peaks in the blood and then is on the way down. There's so many factors that we can't quantify here to make it possible to extrapolate backwards.
So the attempt by Dr. Danziger to back extrapolate wherein she comes up with an alprazolam or Xanax level of 215 or 216 nanograms per milliliter, I believe it was. Is that an accepted or valid methodology for trying to go back and find what a person's level would have been 20 hours earlier?
No, in my opinion, you cannot do that for the reasons I spoke to already.
Now, you've indicated that there's a half-life for alprazolam, but it can vary from 6 hours all the way up to 26 hours. Is that correct?
Yes, sir.
And that varies by the individual, not by the drug.
That's right. So there's some individuals that are metabolizing really slow and some really fast. And then there's people in the middle, of course.
So without testing the particular individual involved, you can't make any kind of generalization about what the half-life might have been.
That's correct.
The 11-hour figure that she used for doing the extrapolation is clearly just an average of all of the people together.
It's not quite that, but that's what's reported as the most common or accepted half-life. But there's a huge range.
Now, you did have an opportunity to view the actual interview of the defendant, did you not?
I did.
Now, in Dr. Danziger's report, she indicated that Mr. Bradley gave her a history of taking, I think, up to 24 tablets in the hours preceding the interview with the Miranda warnings. Is that correct?
That's right. There were 2 taken earlier in the day and then 2 allegedly, I think, after the incident but before the arrest.
Based on your experience and training, do you have an opinion about what effect that would have had on a defendant, assuming that he does not have a long-term exposure or tolerance to the drug Xanax, but had only been using it in any substantial amount for, say, 2 weeks prior to the time of the administration of Miranda warnings?
That's a massive quantity of alprazolam. Most people, for the treatment of anxiety, may take 1 or 2 milligrams, maybe once or twice a day. These Xanax were 2 milligrams a piece, I believe. So 2 times 12 is 24 milligrams. And now there's allegedly 2 times where he took these 12 milligrams, or 12 doses rather. That's just a massive or unbelievable amount of Xanax allegedly ingested by the defendant. And if it's the case, I would expect him to be flat out in a coma state. Maybe not dead, but in a coma state. The Xanax alone won't kill. If you make Xanax with alcohol or some other sedative, it will kill. But it's still an unbelievable quantity of drug.
And did that match up with the observations you were able to make of the defendant's interview that took place from 7:30 on for about a little over an hour on the evening of March 6th, 2012?
No, I mean, he was sleepy, which I think we could explain. He wasn't lethargic. He wasn't in a coma state. He could converse. I don't think he was slurring his speech. He was more mumbling rather than slurring. And there were times where he was clear on in terms of, actually most of the time I believe he was clear on in terms of the answer to the question. So there was, to me, I didn't see any confusion or difficulty in answering some simple questions and some more difficult questions.
Now, the history that the defendant gave to Dr. Danziger over the course of the two different interviews varied from the actual lab results, did they not?
Yes.
Did he give a history of having taken MDMA or ecstasy shortly before the Miranda rights were administered?
Yes, there was some reference to, I believe it was beanies or beans. I wasn't really clear on that, but there was no ecstasy in the defendant's blood and urine, and there were no other stimulants that are related to ecstasy that were available at that time. So there's no methamphetamine, there's no methadone, there's nothing, actually there was no cocaine even in the blood. There's no confirmation of that statement given by the defendant to Dr. Danziger.
In fact, the chemical testing disputed the defendant's account.
That's right.
How about the magic mushrooms, the psychedelic mushrooms that he claimed to have ingested shortly before all of this took place, and he was given his Miranda rights? Any evidence of that in the lab report?
There's no evidence, but typically laboratories don't screen for the hallucinogenic chemical that's found in a mushroom. It's called psilocybin. So the negative result is negative because presumably it wasn't tested for. So
we don't know one way or the other with that one.
Not with the mushroom, no.
How about codeine?
There was no evidence of codeine, and if he had ingested codeine within 2, 3, 4 days of this incident, his urine would be positive for sure.
And how about the promethazine? That's the active ingredient in cough syrup drink that I think that they talked about?
That's right, or Phenergan. You may have heard it as Phenergan. No, there's no evidence of Phenergan or promethazine in the blood and or the urine.
Now, there was a finding in the urine, I believe it was, about codeine. Is that correct?
No.
Or not codeine, cocaine. Cocaine metabolite.
Yes, sir.
Would you explain that to me?
When an individual consumes cocaine, it's metabolized. And the common term would be cocaine metabolite. The more technical term would be benzoyl-ecgonine. It's a real chemical, it's a chemical term you're not comfortable with. So it's okay to call it cocaine metabolite. And that's what was found in the urine. But there's no evidence of recent cocaine use in the blood. I wouldn't expect to find parent cocaine in the blood because time has gone too long since the incident. But if he was using cocaine on a repeated or chronic basis, you would still likely find the metabolite. There was no metabolite. So we do have evidence in the end of recent cocaine use, but not enough evidence to support that he was impaired by it.
How about the hydrocodone?
Hydrocodone was in the urine. You probably know hydrocodone as a drug called Lortab or Lorcet. It's an opioid drug. It's used to treat pain in the urine, not in the blood. So again, there's no evidence, sufficient evidence to say that the gentleman was impaired by the hydrocodone at the time of the incident.
Did the defendant even give a history of ingesting any hydrocodone that you're aware of?
No.
So he's got some drugs in his system that he didn't mention. He's got at least one drug in his system that he didn't mention, and several drugs that he says he took that do not show up.
That's correct.
Now, given the history of taking the drugs at the last time at approximately 4 a.m. on the morning of March 6th of 2012 and the agents conducting the interview at 7:30 p.m. on March 6th of 2012, do you have any opinion about whether the effect of any drugs in the system would have been decreasing or diminishing in effect at that time?
If there was any effect, it would be decreasing at the time of the interview, and then, of course, at the time of the blood draw, which was hours later.
Now, can you, based on the information that was available to you and the Wusthof lab reports and available to Dr. Danziger, as well as the information that she related that she obtained from the defendant directly and the history from him during the interviews, can you or anyone else say with any kind of degree of toxicological certainty whether at 7:30 p.m., approximately 7:30 p.m. on March 6th of 2012, the defendant was under the influence of drugs such that he could not knowingly, voluntarily, and intelligently waive his Miranda rights?
No, and you can't use this blood test done hours later to establish that. It's not possible.
Now, you did view the interview that the defendant gave to the agents, did you not?
I did.
And you've seen people under the influence of drugs, including the drugs we were talking about today here, pot, Xanax, and hydrocodone.
Yes.
And was the defendant in the interview able to answer the questions relevantly?
Objection. In your opinion.
Okay, bench conference.
Let's not use a term that we use in the legal courts all the time. Let's talk about was the defendant able to answer questions logically cogent?
Same objection, Your Honor. It's beyond the...
Okay, let's have a bench conference.
Dr. Goldberger, when Mr. Bradley was asked a question about topic A, did he respond to topic A?
Objection. Same, Your Honor, same objection. I have stated twice.
Did he respond to topic
Topic A.
Okay, I'm going to overrule that. It's a yes or a no.
It's a moral time. I object to the following questions that they was.
Yes, you may.
During your viewing of the interview of Mr. Bradley, did you find any signs of serious impairment by Mr. Bradley?
Objection.
Good afternoon.
We spoke by phone on Friday.
We did.
We did your deposition. And you have to say out loud.
Oh, yes.
Okay. I mean, it's being recorded, so you got to get your answer. As of that date, you had not viewed the DVD. Is that correct?
That's correct.
And was the DVD
Well, even though I saw it, I don't think you could tell the difference between sleeping and passed out.
So, all right. So, but before that, if Mr. Bradley was, as has been testified, seen falling out of his chair a number of times, would that be an indication of impairment, do you think, given the toxicology indication of the drugs in the system?
It could be, but not necessarily definitive proof.
Can't say one way or the other.
That's my point.
And at the time you did actually begin viewing Mr. Bradley when the police got him up off the floor and put him in the chair and began questioning him. At that point in time, he would have been coming down with respect to the alcohol, the drugs in his system. Whatever effect they may have been having on him would have been diminishing at that point from the point previous to that when the drugs were ingested.
If he was even impaired at that point, but yes. Drugs would diminish.
Promethazine with codeine, that's found in cough syrup, isn't it?
Yes.
It's suggested for whatever effect people get from that by drinking it.
You can get high by drinking cough syrup.
Some people do. You know, you're a toxicologist, and you know what people use, what drugs people use.
People have used that before, yes, to get high.
Okay, and so hydrocodone is also an active ingredient in cough syrup.
It can be.
Right. And so if one were to, say, pick up some cough syrup that can make you high, has codeine in it, some has hydrocodone in it, some has promethazone in it.
Promethazine.
Promethazine.
But maybe not. But hydrocodone.
An average person who drinks cough syrup would necessarily know.
Well, the promethazine is what we refer to as a phenothiazine. It's not a narcotic. It has antihistamine-like effect as well as sedating. I think more appropriately is, can they distinguish between codeine and hydrocodone? And probably not, although hydrocodone is stronger than codeine.
So, you know, if an individual, as a toxicologist who has seen people impaired and seen people ingest all kinds of things, if somebody is drinking cough syrup for a high, it wouldn't make a difference whether the active ingredient is promethazine or hydrocodone. Or that the person would even know what the difference is.
Well, sophisticated users of drugs do know the difference. And I don't know how sophisticated the defendant was at that time.
The MDMA, SSE from beans, which you indicated, there was some indication of that in the blood or urine.
That's right.
Okay, in your experience as a toxicologist, do people who use regularly, as Mr. Bradley has been established to do, street-level drugs, do you think they always get it right? That is, the drugs that they get, they know exactly what they're taking?
Maybe not, but Dr. Danziger's report seemed pretty definitive regarding his use of this stimulant.
Well, so are you presuming then that she absolutely got it right, or that perhaps Mr. Bradley had it misrepresented to him as to what he was consuming? I mean, can you rule out that possibility?
No, I can't rule that out, but he may have mowed her down as well. So I'm not really sure. That's the other possibility.
Now, you indicated that if Mr. Bradley had consumed the amount of Xanax,
He clearly would be lethargic and fast asleep. Because essentially what's reported is ingestion of 24 2-milligram tablets of Xanax. That's an unbelief. Because essentially what's reported is ingestion of 24 2-milligram tablets of Xanax. That's an unbelievable amount. It wouldn't kill him because Xanax doesn't kill alone, only in combination.
is there a level?
But that, as I said, is in a amazing figure.
Is there a level of tolerance? Does the person's tolerance who ingests Xanax regularly, is it affected?
Yes, someone would become tolerant to it, but I don't believe the defendant was tolerant, and this is one of the opinions that Dr. Danziger switched on before her final report, because someone who's tolerant to a benzodiazepine like Xanax, when you withdraw the drug from the body, the individual goes through withdrawal, which can be fatal. And there were no signs or symptoms reported by the jail personnel that he was suffering from withdrawal. So I don't think there's evidence that he was using the drug chronically, that he had tolerance to it, and the jail records show that he didn't go through withdrawal. So we're somewhere in between. And my point is, we don't know what the truth is, but we can't say that the truth was definitively impaired by Xanax. We can't say that.
But we don't know one way or the other. That's what you said. We don't know.
That's my point. But I have no evidence that I can pinpoint that says he was impaired by a Xanax or impaired by the marijuana.
Okay, Dr. Goldberger, if Mr. Bradley was observed flat out for between noon and when the police woke him up to interrogate him at 7:30, and was at least one point a police officer was unable to wake him up to arouse him, would that be consistent with consuming a large quantity of Xanax?
It might be, or it might not.
That was the part you didn't see. You didn't see that part of the DVD, right?
No, but I knew that happened.
And when you're talking about back extrapolation, you're talking about on the basis of the medical, on the basis of the toxicological report alone, correct?
That's right. Just taking that number and going backwards.
But a competent toxicologist in making that retroactive determination is not going to rely just on the toxicological report. Wouldn't that be correct?
You hope? Yes.
Right. And so there are other items that if a toxicologist, if you're asked to give a retroactive extrapolation of the influence that a person might have been under in the past, you would want to consider, as you pointed out, field tests. You know, the type of tests that can be administered by a police officer to determine the level of an individual's impairment.
Right, but...
among other things.
That's right.
That's one thing. Okay. And also, if there were eyewitnesses to the behavior of an individual at any point in time, you would at least consider that information, would you not? For whatever it's worth.
Eyewitnesses are useful. In this case, we have a video. That's even better.
Part of it, sure. And so how much of that DVD did you view?
I viewed
from the point in time that the police pulled him up.
To the time that he exited the room. It was an hour and 20 minutes or 30 minutes, whatever that was.
And you indicated that if a blood draw to be definitive with respect to the person's the amount of drugs they have in their system at any point in time, the ideal time is to take the blood at, let's say, the time Miranda was read. That's the point in time at issue.
That's right. But in addition to the blood draw, you would want to document the signs and symptoms of impairment.
Right. And would it also not help to do a face-to-face interview with the individual and to get the person's drug history so you can at least determine tolerance and make those sorts of determinations as well?
Those are important, but that's something that you do at the jail, because if the person has an issue with drug use and tolerance, the jail personnel need to know so they could be on a watch for withdrawal.
Okay, so you have reviewed Dr. Danziger's report, her evaluation, and all the list of things that she had, which she viewed, which she considered in her opinion.
Yes, I think we, in the end, had the same material to review, except I had her report to review, obviously.
You didn't talk to Mr. Bradley?
Well, of course not.
Right. So you didn't have that?
No.
And you didn't have a deposition of the co-defendant who was in the car and claimed to hear Mr. Bradley say certain things at a certain point in time. You didn't have that either?
No.
what opinions can be derived from a toxicological report. Isn't it true that with respect to THC, well, at least your opinion is that there can be no inference of impairment of mental faculties merely from the toxicological report, let's say of THC?
That's correct, and that includes this type of case. It would also include a DUI.
Sure. Right. And so as you're familiar with the laws of Florida, as it relates to that, that a person can be found guilty of DUI both for the way they act outwardly, but also there's a presumption of impairment just from the level of blood alcohol.
Blood alcohol only, so regarding... Right, blood alcohol only, we do have what's referred to as a per se, or presumption of impairment at 08 or higher. But regarding drugs and blood, we have no presumption.
But as you have acknowledged, at least what you acknowledged in your deposition, you are aware that 2 states that have legalized recreational use of marijuana, Colorado and Washington, they have presumed levels of impairment from a level of THC of 5.5 nanograms per milliliter. Would that be correct?
That's correct.
And actually, Mr. Bradley's was higher than that, was it not?
Slightly higher.
So had the law enforcement officers chosen to do so, they could have collected a blood sample from Mr. Bradley at the time that he was taken into custody or at the time that he was read his Miranda rights. He was in their custody.
I don't know all the legal requirements, but I believe he would still have to consent to that. Or there had to be a court order from a judge.
He could have been asked. He could have been asked if he wanted a blood sample. But police officers could have done that.
Sure.
And they could have performed what you call DREs, field tests.
Drug recognition expert.
No, that's wrong terminology. The
Field sobriety exercise.
those.
They could. A situation like this, it would be unusual that those types of exercises would be conducted on that defendant.
Okay, based upon the level of THC in the blood of the time of the blood draw, it was actually 4:00 p.m. on March the 7th, well, 3:55 p.m. Isn't it correct to say that you cannot draw any inference back retroactively to the time of Miranda? Correct? You've already said that.
We can't, especially with the alleged history of the marijuana use dating back to when number alone doesn't support impairment. There have to be other facts considered.
Would brain damage be a factor that a toxicologist would take into consideration or want to consider in making the determination of the effects of blood on that, the effects of THC or alprazolam on that brain?
Not usually. That's generally outside the scope of a forensic toxicologist. As you know, I have some medical background as well, but no, I don't think it would be appropriate to go that way.
All right, so you wouldn't, even if you had that, you wouldn't consider it. That is an MRI or a PET scan result.
I would not, no.
You would describe yourself as, when it comes to opinions about the effects of controlled substances on behavior, on mental faculties, you would describe yourself as conservative, very conservative.
Yes, because I'm asked many times, consulted by attorneys and highway patrol and officers from around the state regarding the effects of drugs on normal faculties. And I would never support the prosecution of an innocent person. So you have to have the competent toxicology as well as backup information, which would include signs and symptoms of impairment, maybe pre and post incident observations. There's a lot to put together. And without that, then I don't think it can be done.
Especially in a death penalty case, would you say?
Of course.
No further questions.
Okay, redirect by the state.
Dr. Goldberger, when you have testified in courts over the number of years that you've been testifying, is that all for the state, some for the defense, split? How does that go?
Well, most of the time it's for the state, but not 100% for the state. So I'm called from time to time to consult with or to testify for the defense.
And you were asked by Mr. Moore that you are on the conservative side in your testimony, is that correct?
Yes, and I think all forensic scientists and toxicologists should act conservatively, not aggressively, and that's how I behave.
Records don't show it, you're not going to testify to.
That is exactly true.
No questions?
No questions.
Okay, sir, thank you for your testimony. You're free to step down.
Thank you.
Okay, other witnesses on behalf of the state.
State called Dr. Patricia Zach.
Ma'am, if you'll step up before the clerk to be sworn.
Raise your hand. Do you solemnly swear or affirm the testimony you shall give to be the truth, the whole truth, and nothing but the truth, so help you God?
Please be seated in the witness chair. And once seated, if you'll scoot that chair forward, do adjust that microphone and do talk into that microphone.
Okay.
Okay, Mr. Brown.
Doctor, would you please state your name and spell your last name for the jury?
It's Patricia Zaff. Z as in zebra, A, P as in Peter, F as in Frank.
And doctor, how are you employed?
I am a professor of forensic psychology at John Jay College of Criminal Justice in New York City.
Can you give the jury your educational background?
Yes, I received my PhD in clinical forensic psychology in 1999. I am a clinical psychologist who did a specialization in forensic psychology, and I've worked only in forensic psychology since 1999.
And can you give the jury a background of your work history?
Yes, so I am a professor at John Jay College of Criminal Justice, which is part of the City University of New York. I've been there for 12 years. Prior to that, I was an assistant professor at the University of Alabama in Tuscaloosa, and prior to that, I was a graduate student. Throughout my graduate training, I worked for numerous agencies. I'm from Canada originally, so I worked for the Correctional Service of Canada and a number of jails and prisons doing intake evaluations and forensic assessments of various offenders. And I have a private practice here in the United States. I've been here since 1998, and I've had a private practice since 1999, flying around the country, testifying on issues mainly on competency, criminal competencies.
And can you tell the jury what organizations or certifications I need?
Yes, I belong to a number of organizations. Probably the most prominent organization is the American Psychology Law Society. It's a division of the American Psychological Association. I currently serve as president-elect of that society, become president in August. I also belong to a number of other international organizations, International Association of Forensic Mental Health Services, and the American Psychological Association as well.
And doctor, have you previously testified as an expert in the field of forensic psychology?
I have, yes.
Can you tell the jury how many times and what locations?
Not too many times, probably about 25 times in total, primarily in Alabama, but then also in New York, California, Florida. I'm licensed in Alabama, New York, and Florida, so that's my primary 3 states of practice. But I serve as a consultant across the United States, so can get temporary licenses if necessary to testify in other jurisdictions.
And
If you could try to make sure you talk to the microphone, because it really does, especially in that corner, they have a microphone and it'll help them hear better.
Yes, ma'am.
And can you tell the jury, have you lectured or been published in this area?
Yes, I've published extensively. I have. I keep count for my university, but I published, I think it's right now about 6 books and manuals, 85 articles and chapters in various peer-reviewed publications, and a couple other books in production right now to be published in the next couple of years. And I give lectures all the time. I train both legal professionals and mental health professionals across the country and internationally on conducting best practices forensic evaluations.
Now, doctor, have you been retained in this case at this point by the state of Florida to evaluate and go through the report of Dr. Olander in this case?
Yes.
And has that been for the purpose of whether or not the defendant's statement was freely, voluntarily, and intelligently?
Yes.
And in order to do that, what have you reviewed prior to court today?
So I reviewed all of the information that Dr. Olander reviewed, all of the medical history that was available, which is the Worcester Hospital records from February 3rd, 2008, the Department of Corrections records, the intake records at the county, the jail, as well as school records and Dr. Olander's records, as well as her raw materials, her testing materials, and her raw scores for the various tests. I watched the video of the post-arrest interview or the interrogation of Mr. Bradley, and I think that kind of captures all of the information.
And have you also reviewed Dr. Olander's written reports,
Yes,
main report or addendum report?
And Dr. Olander's written report and one addendum and one email about the diagnosis. About the diagnosis?
Now, doctor, in this case, at this point, you have not interviewed the defendant himself, correct?
Correct.
And depending upon the jury's verdict in this case, are you set to do that on Wednesday?
Correct.
Now, going through the records, you were able to review the educational history of the defendant?
Yes, I was.
That he had a high school diploma
Yes, correct.
with a 2.6 state GPA, 2.7 district GPA.
Correct.
The IQ test from the Department of Corrections.
Yes.
The medical history, both reported by him and what's been documented.
Correct.
And the psychological history of the defendant.
Correct.
And you heard my cross-examination of Dr. Olander, correct?
I did, yes.
And we go through that history, complete history with her, or did I?
Yes, yes.
Now, let me jump ahead rather than going through a review as well. You indicated you had the opportunity to examine Dr. Olander's, not only her reports, but her raw data. Can you kind of explain to the jury what is the raw data? What did you have to review?
So the raw data, any of these tests that we talk about are instruments, psychological tests. Basically, they're pencil and paper tests. And so when I talk about raw data, typically the test will have, 2 to 10 pages. It depends on how long the test is and what types of things are being tested. But the record form is called. So where questions would be asked of the evaluee, and then the responses would be written verbatim on the record form. And then also, typically, most tests also have the scoring right there on the record form. So you would ask the question, you would write down the defendant's or the evaluee's responses verbatim, and then also score those responses depending on the scale of the instrument. Typically 0, 1, or 2 is how most instruments are scored. And so the raw data simply means all of those record forms for the various tests that she administered.
In addition to that, does her data, what she provides, include her notes or summary of the interview with the defendant, things that he told her?
Yes, her notes, as well as typically we're instructed to write down our observations of the evaluee in the margins or on the papers at various times when we're, because you're asking questions, but you're also observing their behavior. So you're wanting to get a sense of, the content that's coming out of their mouth in terms of the responses, but then also the process, so the manner by which they are answering your questions, whether they're attentive, whether they're engaged, whether they're wandering off, whatever the case might be, write your observations. So both observations as well as verbatim responses, scores as well.
And did the material you reviewed from Dr. Olander include those types of comments and things of her interaction with the defendant, what she observed of him?
Yes, correct. And I believe that Dr. Spicer may have done some of the testing as well, so it's unclear who did what on the various protocols, but all of the raw data is there, and I examined that all.
And in your field, is it common to go back for an expert to go back and evaluate a prior doctor's examination, their comments, their input, and examine their raw data?
Yes, it's very common. Anything that another expert does becomes, in essence, part of the record, and so that would also be something that you would want to review to evaluate as part of your evaluation.
And knowing that it's likely to be reviewed by another expert, is that why you're trained to put your observations down of an individual, his reactions, what you observe, things of that, as you go through the process of testing?
Yeah, in the forensic arena, definitely, you always are cognizant of the fact that you would have two sides to every case, and so you always want to make sure that you're documenting everything so that anyone else coming in to look at it can look at the same information and make this, their evaluation based on what you had observed in your notes and your comments. But generally, just in psychological practice, even if it's not in a forensic realm, you still want to be able to make sure that you're writing down your observations. As you know, it's difficult to remember things over time, and so writing down your observations is just simply the way we're trained to make sure that we're being accurate and recalling details later on when necessary.
And Doctor, in reviewing the work of Dr. Olander in this case, did you notice anything concerning the issue of malingering, what is malingering, and the testing that she did in that?
So in any forensic evaluation, you can only take the defendant's words, so their information that they offer, at face value in terms of getting input from that individual. Everything else needs to be corroborated. So that's sort of the general rule of thumb for forensic work. In any forensic evaluation, there is one issue that always needs to be considered, and that's the issue of whether someone is malingering. Kind of a fancy term for lying or exaggerating or maybe faking mental illness. So in any evaluation that I conduct, because I'm a forensic psychologist, I'm always looking for issues of malingering. I'm always evaluating that in every evaluation, and then sometimes I'll go on to do further formal testing for malingering. And so in Dr. Olander's evaluation, she evaluated for response style, which is another way of saying malingering. But what response style really looks at is the manner in which someone presents. Do they seem like they are presenting in an open and honest manner? Are they providing information that appears to be accurate and valid? And so the test that we have for looking at someone's response style typically ask questions that would be very common for most members of the population to acknowledge, and you're basically trying to get a sense of whether this particular individual is either denying or minimizing or exaggerating on the basis of these responses that are fairly typical. So are they going to deny doing something that most people in the population would admit to, even though it might be something that is, we might be a little bit embarrassed to admit to it. So that's typically what they look for in terms of response style.
Doctor, before you go on, was that the Paul House deception?
Yeah, the Paul House Deception Scales is one of those measures that can be used to evaluate an evaluee's response style.
And is that the one that Dr. Olander used?
She did. She used that one. And then there's also some instruments have validity scales built in as part of them. In essence, looking at consistency of responding. You want to make sure when it's like a 420-item true-false questionnaire that somebody isn't sitting there going true, 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 false, 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 kind of variable responding. You want to actually try and make sure that they're reading the items, and even if you're not in the room with them, there's some scales that are typically built in to look at that consistency of responding. Are they answering the same question, worded slightly differently, in the same way throughout the test? So the validity scales and the Paul House Deception Scales are the instruments that Dr. Olander used to help her make a determination about the presentation style of Mr. Bradley in this case.
Are there any additional tests? Do you feel there's some areas that are not covered by that type of testing, and any additional tests that...
Yeah, so in forensic evaluation, as I said, the rule of thumb is to corroborate everything. So you're always looking for third-party information that's going to corroborate what is told to you by the evaluee. So in a situation where an evaluee is claiming to have symptoms of mental disorder or memory impairments or cognitive deficits of some sort, then there are tests that have been developed to specifically assess the degree to which those symptoms are valid. So it's called symptom validity testing, basically trying to get a sense of whether the symptoms that someone is claiming are valid symptoms. Probably the most common test that's used for the psychiatric symptoms is called the SIRS, the Structured Interview of Reported Symptoms. There are other tests that look at someone's validity of their memory deficits or cognitive impairments. One of those would be the test of memory malingering, the TOMM, the TOM. So that's a typical test to use when somebody's claiming to have memory deficits, to try and get a sense of whether that's valid. And then the SIRS is a test that's very commonly used to look at the symptom validity of psychiatric symptoms.
And in this particular case, given the defendant's claim of lack of memory for certain instances, do you think that TOM test is something that should have been used?
The TOM, yes, definitely. There may be others that I would perhaps use instead of the TOM that just get at it in a little more sophisticated way, a little less obvious, a little less face transparent. And then certainly the SIRS for the psychiatric symptomatology. Absolutely.
And what did you see that you feel prompted me to give the SIRS type test?
Well, I'm always, in general, in any forensic evaluation, I'm looking to corroborate information. And so when somebody is saying that they're having psychotic symptoms, which is, not very common in the population, 2 to 5% of individuals in the population maybe have psychotic diagnoses. When somebody's claiming to have a psychotic symptom, then that's an area where I will delve more deeply to try and look at, what's the history of this, what other symptoms do you have, how does this hang together. So typically it's, what I would do is, when I work a case, I literally get a banker's box or two of all of their mental health records. So usually somebody who has psychotic symptoms has it's a pretty acute disorder. It's something that occurs over time, and there's usually a lot of contacts with mental health. So I will review all of those records. I'm looking for consistency. I'm looking for the history, when the symptoms started, how they play out, whether they get worse, how they react to medication, all of those types of things. In this case, it was, there's really no mental health history records, so you can't look at records for that. So you've got the self-report of the defendant, and so then I would be looking for testing to confirm the validity of what I'm being told by the defendant.
Now, specifically going to what you were asked in this case to opine for it, is whether the defendant waived his Miranda rights in a knowing, intelligent, and/or voluntary manner. Did you look at the Miranda type testing and the raw data you spoke of, testing that Dr. Olander?
Yes, definitely.
And the two types of tests, the Grisso test and the SAMA test, are those legitimate type testing?
Yes, there are basically only two, I'm going to say instruments, which then are comprised of sub-tests. So each of these instruments, there's the SAMA, the Standardized Assessment of Miranda Abilities, published in 2012, relatively recent, but done very well. And then there's the Grisso instruments, which were published in 1998, kind of the gold standard in the field to this point because they've been the only ones that have been, developed by Tom Grisso, who was like, sort of the grandfather of forensic psychology. They're very well-validated instruments. They've recently been revised, but Dr. Olander used the older version of those instruments, which is quite fine, and then the SAMA. So I've had opportunity, I'm familiar with all of those instruments and have had opportunity to review her administration in as far as I can see from her observations and information on the profiles, the raw data, and then I can see, verbatim what the responses were from the defendant when she was asking questions in her evaluation.
And in your career, have you given and reviewed these tests many, many times?
Yes, actually I was a beta tester for the SAMA, which means one of few people in the country who's called upon to, before it's published, test it out, give feedback. My background is in test administration and construction, so.
And did you see any issues or any problems with the presentation of the test to the defendant in that regard?
No, I don't think so. Everything looks quite, fine. The only issue was the fact that the defendant indicated that he didn't have memory for the time that he waived his Miranda rights, so the time of the interrogation. So there's a lot of spaces where, questions would be asked, but then it's like no memory, no memory, no memory, big kind of zero with a line through it throughout the raw data. So it just means there's nothing there for her to score because he has no memory of that time.
And how about the defendant's performance on the Grisso test? How did you tell the jury, how did he perform in that test, and what is your take on his performance?
Yeah, there's 4 sections of that test. One looks at the vocabulary. One looks at his understanding of those words, and basically he's given 2 statements, and he needs to say whether they're same or different. And then there's the function of rights of interrogation, where he's asked questions about those rights and what it means. And he scores within normal limits. He's not impaired on any of them. Dr. Olander in her report notes that he has some inconsistencies on where you give 2 statements and they have to say whether they're same or different. But that instrument is, it's 0 through 12 is the possible scoring, and he scored a 9. So he's, had a couple errors there, but still within normal limits.
And 12 would be the perfect score?
Yep.
And in the other areas on that type of testing, the function or rights of interrogation, comprehension, Miranda vocabulary, those other areas he scored?
Within normal limits, yes.
So what was your overall interpretation of his performance on the Grisso test?
So he was unimpaired on the Grisso test, and that my overall interpretation was that he wasn't showing any deficits in terms of his understanding, reasoning, appreciation abilities that kind of come into play when you're talking about like what it means to waive your rights.
So now going to the interview itself, you used terms knowing, voluntary, and intelligently waiving Miranda.
Yeah.
And can you kind of give the jury a definition of what you're looking for in each of those 3 types of cases?
Sure. So voluntarily is pretty straightforward. It means without coercion. Coercion can be because of some threat that's made, or it can be like the promise of some big inducement, right? We can be coerced by like getting promised something that would just make us do something against our will because it would be so great to get whatever that inducement is. When I look at in terms of the voluntariness, there was nothing in the interrogation situation that led me to think that Mr. Bradley was being coerced in any manner. He certainly wasn't being promised any inducements, and he wasn't being threatened, or the officers were extremely cordial and just very appropriate with him. So in my mind, there was no concern at all for the voluntariness. It appeared to be quite voluntary. In terms of the knowingly, when we talk about competence, which is my area of expertise, we kind of talk about different abilities. And so the ability that goes with the knowing prong of the Miranda waiver is understanding. That simply means, does the person have an accurate understanding of the situation? And there was really nothing that I could see from the interrogation that would show any misperceptions or misunderstandings. So I'm paying close attention to the words that he's using. I'm also looking at his body, his gestures, his nonverbals, all of that. And there's nothing to indicate that he doesn't know what's going on or that he has some misunderstanding of some crucial piece of information. And then the intelligently component, I sometimes refer to as fact or as rational understanding, so taking those facts and then being able to apply them in a rational manner, which means being able to weigh information and select information that would be more appropriate to give in a certain circumstance versus less appropriate to give. And then also appreciation. So that's just taking that factual understanding and applying it to your own situation and being able to make a decision about, me here in this situation. Am I able to, know what's going to happen to me? Do I understand what happens when I waive my rights? Do I understand what it means to give the police information in this situation? And then, of course, along with the knowingly, willingly, and intelligently comes the totality of the circumstance. So always have to take into consideration the totality of the circumstance, which means characteristics about the defendant, how old the defendant is, what his level of education is, whether he was under the influence of any substances, if so, whether those substances were taken voluntarily, willingly, or whether they were slipped into someone's drink and they were taken without them knowing, whether they've had contact with the criminal justice system, what their history is with that, their interactions with the police officers, as well as the situation. Was the interrogation room, were there unusual circumstances about that interrogation room or about the interrogation in some way? So really kind of taking into consideration this whole totality of the circumstances and trying to make a determination about whether this person in this situation was willingly, knowingly, and intelligently waiving his rights.
Okay. And in this particular case, you talked about the situation in the interrogation room. Did the officers let the defendant get up and move about?
Well, the defendant, I believe the defendant probably had leg irons on. It looked to me like that. I didn't actually see them. I'm making that assumption. He was handcuffed as well. And also, had been sleeping on the floor just prior. So there was some testimony earlier about, him being put in a chair by the officers, which is accurate. One of the officers, picked him up and put him in the chair because he was, shackled and handcuffed and kind of sleeping or had, is in the process of being aroused, and so put in the chair. And then they had him do a few demonstrations at various times, so they got up and they moved around, and so yes, he's free to move in essence. I mean, he's not getting up and doing any big gestures, but they have him play out certain situations and where he was in location to other people and in relation, to other people. And so, yes. And
during that time when the defendant is up, moving about, did you either see or hear anything from the officers that in any way at that point threatened the defendant or anything of that nature when he's up and now?
No, not at all. My impressions were that the officers were very cordial, very appropriate with him. Yeah.
How about the early part of the interview itself when the Miranda rights were read to the defendant? Did anything occur during that gave you any significance in your opinion as to whether or not he voluntarily, freely, and knowingly waived his rights?
So that first part where he waives his rights, it happens right at the beginning of this interrogation. And so they put him in the chair, and he's, kind of waking up, and they kind of say to him, like, are you okay to talk with us? We have to go through some things. And one of the officers pulls up next to him and takes him through each of his rights. And after each of his rights, he mumbles, he says, like indicating an understanding of that right. Officer moves on to the next one, and after each one, he kind of gives this It's mostly an like a mumble, but And then the officer asks him if he understands that he's waiving his rights, and he says, "Oh, I understand," and then they carry on. So I took that to mean that he was, he's had experience with the criminal justice system before. He's been in an interrogation situation before. I just took all of that to mean that he understood his rights and was waiving them willingly and moving forward with answering questions.
Okay. And would that be consistent with his performance on the Grisso test?
Yes, yeah, absolutely.
Then there was a spot at about 7:44, again at 7:57, 8:21, and 8:24. And I'll focus first on the 7:44 one, where he a clarification of his position to the officers in relation to where the gun. Do you recall that portion of the interview?
Yeah. So 7:44 is the timestamp on the video, and the video I think starts around 7:36, so like 7:30 at night, 7:36 at night, and it's about 8 minutes into the interrogation. So the waiving of the Miranda rights at the beginning takes about 2 minutes, and so it's about 8 minutes into his interrogation. So he's just kind of waived his rights, and he's going through and answering questions, where he is very clear to clarify for the officer. The officer's trying to get a sense of how Mr. Bradley came into possession of the gun, like literally to hold the gun in his hand. And so the officer's kind of, I guess, making some assumptions about where the gun is and how Mr. Bradley reached over for it. And Mr. Bradley's very clear to clarify that I said the gun was over there. I didn't say anything about reaching for it. And he does this a number of times throughout the interview, and I'm paying close attention to that because those types of statements give me some indication as to whether he understands what's going on in the circumstance, in the situation. And so my impression of those statements are that he has a clear understanding of what's going on and is making attempts to clarify even more for the officers what his position is, the information that he's giving.
And did the defendant throughout the interview multiple times do that additional clarification with the officers as far as what he was saying?
Yes, numerous times throughout the interview, and in fact at one point says, "Now don't put words in my mouth, sir." Like clearly knows, my impression is that he clearly understands that words make a difference in this situation. So he's being very careful about the words he's using, and he's clarifying and correcting the officers when they're using words that he didn't use, or when he feels they're putting words in his mouth.
And you also look to see if there are any instances where a person would indicate his appreciation of the rights that he has waived.
Yeah, so...
And what is meant by that?
Right. So what I'm looking for when I'm watching those interrogation interviews is I'm basically looking for deficits in understanding, so some situation where they're giving incorrect responses or responses that don't really make sense. I'm also looking for, whether they have an appreciation of what it means to, be talking to the police, to be telling them this information, right? It perhaps incriminating yourself, right? So I'm paying close attention, and so several times throughout the interview, he gives indication of his appreciation of the importance of, speaking with the police. At one point, he's giving information about the gun, and he's very, he's concerned about we called her his baby mama in the interrogation, but the mother of his child, his the individual who was with him in the vehicle at the time. So he's giving indications to the police officers that he doesn't want to incriminate her by giving information. So he was kind of saying like, oh, I don't want to get her in trouble. And at one point he's talking about, well, 20 years, 30 years, like, in essence, what difference is it going to make if I give this one piece of information? We're talking 20 years, 30 years. So there's a number of instances throughout his statements that says to me that he has an appreciation of the severity of the situation and of the of what it means to be waiving his rights, to be speaking with the officers in this situation. He understands that giving pieces of information could add more time on. He certainly has an understanding of the severity of the situation that he's in with looking at 20 or 30 years, in that post-arrest interview.
So, for instance, when he says at about the 8:05 mark that he doesn't want to get his girlfriend into trouble, what does that say to you?
Yeah, that says to me that he understands that giving information to the police can be used against him or against her. So, doesn't.
The same thing again at 8:06 and 8:08. He indicates he's worried about saying anything against his baby mom.
Yeah. A number of times throughout the interview, he is concerned about incriminating the mother of his child, who.
Now, at the 8-minute mark, is there a discussion where he talks about regarding when, how, and where he got the gun and whether that could incriminate himself? Do you recall that portion of the interview?
Yes, I do.
Can you talk to that jury what that signifies to you?
So there's this discussion that goes on about how he has obtained, they're trying to get a sense of like how long he's had the gun, where did he obtain the gun, and it was my impression that it wasn't actually his gun, that his girlfriend had gotten the gun, or had obtained the gun, or it was her gun. So he's very concerned that in giving information, he might be incriminating his baby mama, his words. And so that shows me that he is able to complete those mental gymnastics that are required to know that I'm giving this information, but not only could it incriminate me, it could incriminate someone else. So it shows to me as sort of a level of processing that indicates that he's aware of the severity of the situation and understands the risks in giving information.
Now, there's a spot of approximately 8:18 where he gives the officers an approximate amount of time that's elapsed from the hotel to the shooting of the deputy.
Right.
That's approximately 20 minutes.
Right.
So he's fairly accurate. What does that say to you? What do you interpret from it?
So that's another thing that I highlighted in my report, because as I keep saying, what I'm doing is paying attention to everything he says as well as how he says it. And everything has to be corroborated, right? So I'm looking for third-party information that corroborates everything he's saying. So at one point, they're trying to get a sense of like how much time has passed before this incident at the Econo Lodge and when he comes into contact with the officer. And so they are asking him this in the interrogation. And so he says, it's about 20 minutes. So he's calculated, and that is accurate. That is accurate information as confirmed by the police report. So it says to me that in that moment, he has a reasonable perception of time. He understands, he has memory for the events that took place and memory for the amount of time that has lapsed between various pieces of the event.
Doctor, putting everything together, were you able to form an opinion about whether the defendant, his waiving of Miranda, was a knowing, intelligent, voluntary?
Yes, I did not see anything that would indicate that it was anything other than voluntary, knowing, and intelligent. I didn't see any indication of impairment of any sort with respect to waiving his Miranda rights.
Can I have one moment?
Yes, you may.
No further questions at this time?
Okay, what I'm going to do is go ahead and take an afternoon break. It's 5 minutes after 3. We'll take a break for 10 minutes. Ask you to be back here at 3:15. So during this break, you must continue to abide by your rules governing your service as a juror, and we'll be in recess for 10 minutes. And now I'm going to allow you to recess too, but recess after the jury leaves.
Thank you.
Okay. And then-
All rise.
Okay, please be seated. And Dr. Zaff, you could go ahead and be back here at 3:15, and then we'll put you on the stand, and then we'll bring the jury in.
Okay, thank you.
Okay, thank you. Court will be in recess until 3:15.